Hi, my name is Kamil, and for the past 25 years, I've dedicated my life to serving in the government sector. I started out as a humble clerk, but through hard work and commitment to excellence, I climbed through the ranks and eventually earned the position of senior officer. It's been a journey I'm proud of. Recently, I was approached by the press to share my thoughts on the employment challenges faced by civil servants in Malaysia. Believing it was an opportunity to shed light on important issues, I expressed my honest opinion. Unfortunately, my views didn't sit well with my superiors. Then came the turning point. On 30th August 2024, I received a notice from the Public Services Commission that I was dismissed for speaking to the press without prior permission from my head of department. Despite my spotless employment record, that single act led to my termination. Now, I find myself facing financial hardships. I am the sole breadwinner for my family, while school-going children and elderly parents who rely on me. Please guide me on what I can do.
Mr. Kamil, thanks for coming in. Based on your situation, you have the right to apply for a judicial review. Under Order 53, Rule 2, Sub-Rule 4, it allows any person who is adversely affected by the decision of any public authority should be entitled to make an application. Hence, anyone who is adversely affected by the decision of the public authorities may make an application for a judicial review. As for QSR Brands Berhad, the court will only deem a person who has been adversely affected if his personal rights and fundamental liberty are infringed or above the infringed, or when the case brought to the court is one of the public interest litigation. Other than these two grounds, the court will not grant a judicial review as it does not amount to being adversely affected. Looking at our situation, it is evident that you have been adversely affected as you have sufficient personal interest with the dismissal by the PSC, which led to you losing your job as the sole breadwinner of your family. You have definitely personally been affected by the PSC decision, hence you do have locus standi to request for a judicial review. Under Order 53, Rule 2, Sub-Rule 2, you can also ask for specific remedies. The first one is certiorari, which means asking the court to cancel or quash the PSC decision to dismiss you. Alternatively, you can also request for a declaration to affirm your rights in this situation. There's also a case called Sukumar Balakrishnan against Chief Minister State of Sabah, where the courts had allowed both remedies to be sought together at once. So based on your situation, we can see that the first issue at hand is whether the PSC had breached natural justice in denying your request for an oral hearing, given that you have requested for one. So despite Article 135 Clause 2 providing for reasonable opportunity of being heard, the interpretation of reasonable opportunity has varied, particularly on whether it includes a right to an oral hearing. So initially, the courts had adopted a restrictive approach where oral hearings were not made mandatory unless explicitly required. For instance, in Najah Singh, it was held that the phrase reasonable opportunity of being heard does not inherently necessitate an oral hearing. So it emphasizes that written representation is sufficient. So this was also reinforced in Zainal bin Hashim, and it was later affirmed in Ghazi against Muhammad Hanif. However, in Uchrabadi's case, where he challenged his dismissal after testing positive for drugs, where he raised several issues in his written representations, the Court of Appeal, referring to Raja Abdul Malik, had found that oral hearing may be necessary in situations where there are contradictions between statements or complex facts, or even issues that cannot be adequately resolved through written submissions. However, the Federal Court later overruled this decision, citing precedents like Ghazi, Zainal, and Najah, that given that neither the Constitution nor the General Orders explicitly requires for an oral hearing. So this position was also upheld in the Kerajaan Malaysia against Tay Chang Wat. But don't worry, Mr. Kamil, subsequent cases have introduced a more liberal approach as courts begin to acknowledge that in certain circumstances, oral hearing might be necessary to uphold fairness. The federal court case of Yusof bin Sudin had expanded the principle and ruled that oral hearings can be warranted in situations where a public servant denies the charges against them and provides credible exculpatory evidence.
Continuing from where my colleague has left off, Mr. Kamil, you must first understand that under Article 135 Clause 2 of the Federal Constitution, you are guaranteed a reasonable opportunity of being heard before your dismissal. This is a fundamental principle of natural justice, ensuring fairness, especially in cases like yours, where the stakes are high. Now, the courts have increasingly emphasized the importance of procedural fairness in recent decisions. Let me just give you some examples. In Vijaya Rao Subramanian, the Court of Appeal made it clear that oral hearings should be granted when requested, especially when necessary to ensure an effective defense, like in cases with conflicting evidence. Similarly, in Abdul Ghani Cheman, the courts reaffirmed that procedural fairness is the minimum standard required in disciplinary proceedings. In your case, Mr. Kamil, there are several factors here that make your argument even stronger. First being your long service record. With 25 years of exemplary service, your dismissal has significant personal and professional consequences, which deserve the highest level of procedural fairness. The second is the financial and reputational impact. The severity of this decision means it should be handled with the utmost care and fairness. And thirdly, your explicit request for an oral hearing. This was denied, despite the fact that recent cases like Vijaya Rao has shown that such hearings are often necessary to ensure fairness. While the earlier decisions like Najar Singh and Zainal Hashim suggested that written representations might suffice, recent cases has taken a liberal approach. For instance, like my colleague has said just now, Yusof bin Sudin case, the courts recognize that oral hearings are essential in situations with significant personal stakes like yours, Mr. Kamil. So in summary, Mr. Kamil, we believe that the PSC's decision to deny you an oral hearing was inconsistent with the current judicial stance on procedural fairness.
Alright, so now let's discuss your concern regarding the PSC's refusal to disclose the inquiry report. This raises the key issue of whether such a refusal violates your right to a fair hearing and your ability to defend yourself effectively. So first, any material relied upon by an adjudicating authority to make a decision must be disclosed to the individual concerned. So you must be given the opportunity to explain and, if necessary, refute that material. So the cornerstone of natural justice is that no material should be used against you without allowing you a chance to respond. So for example, I'll give you a case. Like in the case of B. Surinder Singh Kanda and the government of the Federation of Malaya, the Privy Council ruled that a failure to provide the individual with a copy of the inquiry report rendered the dismissal proceedings invalid. So Lord Denning emphasized in that case that the right to be heard includes the right to know what evidence has been presented and what statements have been made about you. So you must also be given a fair chance to correct or contradict such information. So similarly, in the Malaysian case, we have Rohana binti Arifin, where the court ruled that denying access to relevant documents would violate the right to a fair hearing. And then I'll give you another case, which is in Linko case, denying access to evidence could amount to a denial of natural justice. So, however, in that case, the appellant didn't request to examine the file, so no breach occurred. So this means you must formally request access to the inquiry report, and if denied, it should strengthen your case. However, in Sabah Sivan, the court found no breach of natural justice because the material in question wasn't shown to the decision makers and this didn't influence their decision. So the Privy Council in that case held that the letter contained material on which some of the charges were prepared by the disciplinary authority, but the letter was not shown to any member of the community inquiry. So it could not therefore influence them in their report on the charges that they were investigating.
So, Mr. Kamil, Maybe you can argue that denying you access to the inquiry report has similarly deprived you of adequate notice and a fair opportunity to prepare your defense. Referring to Lord Denny's judgment in Surinder Singh Kanda case, it is your right to know what evidence has been used and what allegations have been made against you. Without the report, you are disadvantaged in refuting or clarifying the case against you. Similarly, in the Rohana case, the court ruled that withholding relevant documents handicaps the individual's ability to mount an adequate defense amounting to a denial of natural justice. Thus, Mr. Kami, you may argue that the denial of the inquiry report violates your right to review the materials, and you can also argue that the decision is procedurally flawed due to denial of access to the report. In addition to that, the Lim Kur case also supports your position. It clearly stated that if such a request of evidence have been made and denied, then there will be grounds to challenge the decision. Therefore, it is crucial that you formally request the disclosure of the inquiry report. And if the PSC denies your request, then you will have a strong basis to argue that your right to natural justice has been violated. However, I must point out that not all cases will align with your circumstances. For instance, in the Samba Siva case, the court found no breach of natural justice because the matter in question was not shown to the decision makers and thus did not influence their conclusions. However, Mr. Kamil, in your situation, the inquiry report has already been prepared and is likely to play a significant role in the PSC's decision. So this makes your situation distinguishable from Samba Siva case. To summarize, you should request the disclosure of the inquiry report as soon as possible, and if the PSC refuses, you can challenge their decision on the basis that it violates your right to a fair hearing and denies you the opportunity to mount a proper defense. And this denial can be argued as a breach of natural justice.
So, Mr. Kamil, regarding your concern on whether you could succeed in challenging the PSC's decision in denying your request for legal representation, we could look into the England and Malaysia's position on how they resolve this issue. Although in the case of Pet and Greyhound Racing Association, or PET1 for short, it was ruled that the plaintiff concerned was facing a serious charge whereby his reputation and livelihood is affected, that natural justice demands that the plaintiff should be represented through a lawyer. So, however, later in Pet 2, the court treated the contention in Pet 1 as obiter and argued that a plaintiff does not have a right to appear through an agent unless this right was expressly denied.
So, Mr. Kamil, continuing from what my colleague has mentioned earlier, the general principle was then laid out in this case of Enderby Town, where the decision to allow a legal representation before a tribunal lies within the tribunal's discretion, and there is no absolute right to such legal representation. The Court of Appeal in the case of XP Tyrant further outlined some criteria for consideration when deciding whether to permit legal representation, so such as the seriousness of the charge, and potential penalties, and even maybe the likelihood of legal points arising. However, it is not exhaustive. So how about Malaysia's position? In Malaysia, the court in Sitambaran and Attorney General followed the principle in Enderby. But because in this case, the Sitambaran case, the plaintiff in this case never raised the matter of legal representation at the inquiry. Therefore, the issue of the exercise of the discretion by the chairman of the inquiry never arose. Another case worth mentioning would be the federal court case of Federal Hotel Sdn Bhd, whereby the right to legal representation is seen as a right if the tribunal allows representation by a lawyer on one side of the party but denied the same for the other party. So after all of that, Mr. Kamil, just to conclude, you are highly likely to succeed in challenging PSC's decision in denying your request for legal representation. So a few points that you may argue could be that firstly, you face financial difficulties as a consequence of this dismissal because of how you are the sole provider for your family. You have to support not only your children who are still in school, but also your elderly parents who are currently living and dependent on you. So all of this clearly showcases that your livelihood is indeed affected by the dismissal, and that your excellent employment reputation will also be tarnished. So these are similar as the cases of Pet 1 and XP Tyrant. And if your request for legal representation was made during the hearing, then you may also question the exercise of discretion of the adjudicator. Moreover, if the other party was granted a lawyer but you were denied the same, then you may also use this ground to substantiate your right to legal representation. Otherwise, it would be a breach of natural justice.